Air conditioning laws in Arizona, what Tucson landlords need to know in 2026. We're currently in the hottest part of the year. This is when air conditioning or AC units are stressed the most and odds of breakage are the highest. If the AC in your rental breaks and you don't repair it immediately, some serious consequences could result, including a tenant lawsuit or an attorney general complaint. The goal of this video is to help you protect yourself from the risk of a broken air conditioner. Hi, Steve Schultz here from Blue Fox Properties. Let's get right into it. So in order to address this issue, we need to explore three things. Number one, the law. Number two, the current attorney general's stance and the political climate. And then three, how to protect yourself. So let's get to the law. First of all, my disclaimer. I am not an attorney. If you need legal advice, find an attorney that specializes in landlord-tenant law. So the following is for informational purposes only to give you a basic understanding of what impacts you as a landlord. So the law is found in the Arizona Residential Landlord and Tenant Act. You can actually Google that, Arizona Residential Landlord and Tenant Act, and it'll pop up a link that you can click on to actually download the PDF if you like. So in the Landlord-Tenant Act, or the Act as it's often referred to in our industry, there are many Arizona revised statutes, or ARS. And so the first one that I'm going to reference is ARS 33-1324, and it's titled Landlord to Maintain Fit Premises. Now in this statute, it says in paragraph A4, maintain in good and safe working order and condition all electrical, plumbing, sanitary, heating, ventilating, air conditioning, and other facilities and appliances, etc., etc. So air conditioning is included in this paragraph for something that the landlord has to maintain in good and safe working order, as the statute states. Now in paragraph A6, it goes on to state, supply running water and reasonable amounts of hot water at all times, reasonable heat and reasonable air conditioning or cooling where such units are installed and offered when required by seasonal weather conditions. And then it continues on with other things. So the important thing to realize here is it says reasonable. And the question is, what is reasonable, right? Everybody might have a different definition of what reasonable is. You as a landlord might have a different definition than that of the tenant. So that's the first thing that's pretty ambiguous. And the second thing, it says when required by seasonal weather conditions. So here it doesn't specifically state if there are certain temperatures, if there's specific times of the year, you know, is this between May and October? It's again, very ambiguous, very generic, but this is how the law reads. So the next statute, ARS 33-1363, titled Self-Help for Minor Defects. And so paragraph A says if the landlord fails to comply with section 33-1324, which is the statute we were just talking about, and the reasonable cost of compliance is less than $300, there's that word again, reasonable, or an amount equal to 1/2 the monthly rent, whichever amount is greater, the tenant may recover damages for the breach under section 33-1361, subsection B, or may notify the landlord of the tenant's intention to correct the condition at the landlord's expense. But wait, there's more, because this is a part that a lot of folks don't realize. It says after being notified by the tenant in writing, if the landlord fails to comply within 10 days or as promptly thereafter as conditions require in case of emergency, the tenant may cause the work to be done by a licensed contractor. So this is paragraph I'm pointing out to you because this is what sometimes tenants will refer to, and it's important to understand that notification period, that 10-day notification period. But this is what they also refer to, attorneys will refer to as the self-help section of the statute. So again, that was ARS 33-1363, self-help for minor defects. And so the self-help there is for the tenant. Now it goes on in ARS 33-1364, and this is titled Wrongful Failure to Supply Heat, Air Conditioning, Cooling, Water, Hot Water, or Essential Services. And so in this statute, paragraph A reads, if contrary to the rental agreement or section 33-1324, which again is the first statute I'd reference, the landlord deliberately or negligently fails to supply running water, gas, or electrical service, or both if applicable, and reasonable amounts of hot water or heat, air conditioning, or cooling. Now here again, this is something, remember the title is wrongful failures, and this paragraph says deliberately or negligently. So what that means is if you are deliberately not making the repair, that is different than you're trying to make the repair, and let's say the HVAC contractor went out and there's a part that is on order and it's going to take a week to get that part, right? You're not deliberately or negligently failing to supply that air conditioning. It's that you're waiting for the part, right? right? So you're actively trying to solve the problem. And this is where most attorneys would say, hey, as long as you're actively trying to solve the problem and it's out of your hands as far as something like that, ordering a part, you're good. This shouldn't apply. But this is something to be aware of as a landlord, because again, tenants sometimes will point to this, and even though they're waiting for a part, they're saying, hey, wait a minute, you're deliberately and negligently failing to supply air conditioning to my house. Well, that's not the case, and most attorneys, again, would argue that that's not the case. So in paragraph A3, it goes on to say, procure reasonable substitute housing during the period of the landlord's non-compliance, in which case the tenant is excused from paying rent for the period of the landlord's non-compliance. In the event the periodic cost of such substitute housing exceeds the amount of the periodic rent upon delivery by tenant of proof of payment for such substitute housing, tenant may recover from the landlord such excess costs up to an amount not to exceed 25% of the periodic rent which has been excused pursuant to this paragraph. So that's combined with paragraph F then, that goes on to say, in addition to the remedy provided in the paragraph 3 of subsection A, which is the one I just read to you, in the event the landlord's non-compliance is deliberate, again, there's that word again, deliberate, the tenant may recover the actual and reasonable cost or fair and reasonable value of the substitute housing not in excess of an amount equal to the periodic rent. So that 25% plus at 1 times is where it comes out to a 1.25 times calculation. Now, understand, per the Landlord-Tenant Act, this is saying if that's deliberate and negligent. However, that being said, it's also kind of setting a baseline. So in other words, if a tenant had to be out of the property, let's say for a week, to be out of the property while that air conditioner is being repaired, that doesn't mean they can go stay at the Ritz-Carlton for a week, right? Because that's probably going to far exceed that 1.25 times the rent for that rent period, right? And so that's where this comes into play, and so something to be aware of. So again, all those statutes are in the act, and it's referenced there. So again, if you'd like to take a look at those, go ahead and download that act by Googling Arizona Residential Landlord and Tenant Act, and you can download that. So that covers the law piece. So before we get to the next section, don't forget to subscribe for more landlord tips like this, and feel free to contact us if you would like us to manage your Tucson rental house. So let's continue. So the next thing I want you to understand is the current Attorney General's stance and the current political climate. So there are 2 documents I'm going to refer you to that are actually on the Arizona Attorney General's website, and this first one is titled Attorney General Mays Warns Landlords About Air Conditioning Failures, Reminds Tenants of Their Rights. And this one was actually posted April 7th of 2026. So we're in June of 2026 right now, so just a couple months ago. And I'll put up on the video here too a link so that you can see where to access that. But the summary of the article boils down to a few points. One is it's warning landlords of their obligations under the law, and then it's reminding tenants of their rights under the law. Now, it also states that, quote, in the cities of Phoenix and Tucson, rental units that use air conditioning cannot exceed a maximum temperature of 82 degrees in all habitable rooms, end quote. So I'm going to speak to that in just a moment about another document that was actually proposed as legislation. So that 82 degrees in Phoenix and Tucson, this is specific city code. This is not in the Arizona Residential Landlord Tenant Act, which actually is statewide. So what does that mean? Well, if you are, let's say, outside of the city of Tucson and you are in Marana or Oro Valley, or you're just simply outside of the city limits in the county, that law does not apply to your rental in that area, similar to Phoenix as well. So that's the thing to keep in mind there. That's city of Tucson, city limits is where that law applies. Again, Landlord Tenant Act is a statewide law, and it doesn't have that language. Remember, in the act, it had the language about reasonable. And so it's the question, right, of what is reasonable. So that Tucson City Code is actually chapter 16, section 16-11B2A, if you're interested in checking it out. And what it says there is every dwelling unit, guest room, and congregate resident shall be provided in all habitable rooms with either mechanical cooling or an alternate cooling method to assure a safe living environment. Cooling facilities shall be installed and maintained in a safe condition and in accordance with the manufacturer's recommendations and comply with the following. Paragraph A is what we were just talking about. Air conditioners shall be capable of producing ambient temperature at or below 82 degrees, and measurements shall be taken at a distance 3 feet above the floor in the center of the room. And then B is evaporative coolers shall be capable of producing ambient temperatures below 86 degrees. And then again, again, measurements taken distance of 3 feet above the floor at the center of the room. And this code was actually adopted in March 9th, 2021. Now, this, if you caught that, it says every dwelling unit. So the interpretation of this, what the attorneys have told us, is that means nothing's grandfathered in. So it doesn't matter if your property was built in 1921 or 2023. This applies. So something to be aware of there. And then the article by the Attorney General goes on to encourage tenants to file a complaint with the Attorney General if their landlord isn't compliant. So that's the first thing to get a feel for what the Attorney General's take is as it relates to air conditioning landlords. So let's move on to the second document I'd like to point you to. And this was actually done a couple months early in the year. This was February 12th of this year. And this one is titled Attorney General Mays and Senator Kuby announce landmark legislation to protect Arizona renters from extreme temperatures. And again, I'll put the link here so you have it if you'd like to go download that article. But here are the key points. One, it's proposing modification to the Arizona Residential Landlord Tenant Act, creating that statewide requirement. And so it's trying to establish that for a fit premises to be considered fit and habitable, the indoor air temperature must not exceed 82 degrees Fahrenheit. So that's taking that Phoenix and Tucson city code and applying it statewide. It also goes on to say it prohibits landlords from evicting tenants during any week when outdoor temperatures reach 90 degrees or higher on 2 or more days. Now, this is something to me that's quite controversial for landlords, because if you've spent any time here in Tucson or Phoenix or many of the other areas here in Arizona, 6 months out of the year, the temperature is more than 90 degrees for 2 days or more in a row, right? And so this would basically eliminate the ability for landlords to evict for half of the year. So this is something really, really controversial. Again, very, if you will, pro-tenant and anti-landlord, if you will. So something to keep in mind. And then it goes on to give examples of all the landlords the Attorney General has sued. So to summarize it, the Attorney General's stance is very anti-landlord. In fact, apparently there are articles where she has gone on record and said property managers are like the cartel. And so you want to really protect yourself and understand what the Attorney General's stance is. As a landlord, you need to diligently protect yourself. So understanding what the political environment is currently here in Arizona and what the Attorney General's stance is as it relates to landlords is really important to understand. All right, so let's get on to the main event, if you will. How do you protect yourself? So now that you understand a little bit about the law and kind of what the political environment is and the Attorney General's stance, what do you do? So the first thing is just understanding that political environment and where things are and where it looks like they're going. So I would predict that landlord requirements will continue to be more stringent and onerous. And should you be in challenge in court, you're likely going to lose. So avoid court, right? I mean, don't get there. Do everything you can to avoid that scenario. Number two, I would recommend you conduct a spring air conditioner inspection every year. That way, going into the peak air conditioning season, everything's as good as it can be, right? You've done everything you can to try and avoid any of those failures. The next thing is, the moment a tenant reports an AC failure, respond immediately and document everything. Next thing, always use a licensed HVAC contractor. There's a temptation sometimes for people to send a handyman or somebody else. Always use a licensed HVAC contractor, because it ever comes into question, you don't want the tenant to be able to say, yeah, that cheap landlord just sent the cheapest person they could find to go do something and the fix didn't last and it was a bigger problem, whatever the case may be, right? So you always want to make sure you use a licensed HVAC contractor. Next, have a backup plan ready. So, maybe that's a portable AC unit or units. Maybe you're prepared to spend some money on hotel allowance if that's what comes to pass. So be prepared for those alternatives. And just keep in mind too, a lot of those alternatives, although they might seem pricey on the front end, going to be cheaper than a lawsuit if you were to end up in court. And then the last thing is, build an emergency HVAC clause into your lease that outlines your response timeline and tenant obligations for reporting issues. So again, you're trying to be proactive and identify these things so that, again, should it ever become an issue, you've done the best you can to protect yourself. So I hope this video helps you understand the various factors that come into play and ultimately helps you protect yourself. Don't forget to subscribe below, and I'll see you on the next video.